Hello, hello.
Good morning, San Diego. Mental health assistance and care, as in the care
Okay.
act, as in care court. The subject of the press conference that's about to get underway here at the County Administration Building. We'll be visiting with you in just a few moments, but first, here's Zach.
You can come here. You can be to my right. Come on. You just stand here. Over here. You can both be right here. Yeah, of course. Oh. Okay, thank you. Good morning. My name is Nora Vargas, and I'm the chair of the San Diego County Board of Supervisors. I want to thank you for joining us this morning. We are here today to announce the launch of the San Diego County's CARE Act program. It starts next week. It's starting October 1st. San Diego County's CARE Act program will create a new pathway to connect individuals struggling with mental health conditions to voluntary treatment through a civil court process. This program represents the latest tool to be added to our county behavioral health services tool belt as part of a statewide effort established through SB 1338. As a county, we have and will continue to prioritize and make substantial investments into our behavioral health system that includes standing up this program. It is a priority of ours to fully build out a system that connects people to the care that they need. It is important to note that this new program has a fairly narrow focus. It is a program for adults 18 years and older, not for our youth populations. It is intended to serve some of the most severely impaired, specifically San Diegans living with untreated schizophrenia or other psychotic disorders. These are individuals whose mental illness is severe, persistent, and may cause behavior that interferes with activities of daily living. The CARE Act program is a focused initiative that may help increase accessibility to care and support people with their circumstances to stay engaged. It is important to note that this is not an emergency court, and it is not intended to be utilized as a crisis service. It is very much a process, a new process that we're standing up in partnership with the San Diego Superior Court, the public defender, legal advocacy, contracted service providers, and our community partners. To better understand the CARE Act program, I want all of you to imagine with me the life of someone with schizophrenia or psychotic disorder who has experienced challenges maintaining connections to treatment. Let's call her Sarah. Sarah is 53 years old. She lives here in San Diego County. She has schizophrenia, and for years she has been connected to treatment, but in the past has always cycled in and out. Most recently, she's been in a treatment program, but she doesn't always participate. She has some family locally, but lives in a residential family and often disappears for days at a time. As it is for so many, this has been a revolving door for Sarah and for those who care and are trying to help her. This is where the CARE Act comes into play and can assist a person like Sarah. I want to make sure that we have Dr. Bertman come up here and give us a little bit of a perspective of what the next steps are and how this would impact Sarah.
Thank you, Chairwoman. Thanks everybody so much for being here. I feel like I've probably already talked with most of you about this. So if a family member of somebody like Sarah's makes the decision that CARE Court might be right for Sarah and for their family, they may submit a petition to the Superior Court to have Sarah's case considered for the establishment of a CARE Act program case. The court will review that petition. The most important consideration that the court will be looking for will be the diagnostic eligibility criteria. The chairwoman just mentioned that this is a program that has a pretty specific And in the context of the kind of broader world of behavioral health diagnoses, a pretty narrow focus. It's on schizophrenia spectrum disorders and some other psychotic disorders. Those are the folks whose situations, whose care is meant to be addressed through the CARE Act program. That excludes many folks with serious mental illness, many folks with behavioral health conditions. If the eligibility criteria are met at a very sort of basic level, and Judge Kimberly Legata from the Superior Court will take the podium after I speak and spell out some additional details around this. If those basic criteria are met, Behavioral Health Services, I'm the Director of Behavioral Health Services, will be engaged and will be asked to conduct an investigation. We have 2 weeks, Behavioral Health Services does, to conduct an investigation which will involve really sort of 2 primary aims. One of those aims is to confirm that the case in question, that the potential respondent is in fact eligible for the CARE Act program. So that would be confirmation of diagnosis, understanding better the broader circumstances surrounding the case. So for example, CARE Act program is meant for people with this set of diagnoses who are not engaged in care consistently, right? So these are people who are needing stabilization, needing something additional to keep them engaged in care. So we would aim to gather that additional information. And then the other thing that we would be doing would be engaging, really trying to establish something of a therapeutic alliance with the person on whose behalf a petition has been filed. And that's really, really important. It's important to the effectiveness of our ability to actually gather the information that's necessary. And it's important to the ongoing care and stability prospects of the person who's had a petition filed on their behalf. So what we'll aim to do, in fact, is, as kind of a best outcome during this 2-week period of investigation, will be to engage the petitioned party in care without having an actual CARE Act case established. So we have that opportunity and we have that motivation with the CARE Act program to do intensive, robust engagement and to see if before a CARE Act case gets established, so really during that 2-week period, though there is an extension that we can also take advantage of, we want to get that person engaged in care. The most important metric of success, I would say, for the CARE Act program would be among folks who are petitioned in, how many can we engage in care without a case being established at all? And that's really the spirit of the CARE Act program. It's about engaging with people to get them into care and ensuring that that care is longitudinal, that it remains in place over a long period of time. That's a really critical aspect of this program and of what we know works best in behavioral health care generally. We do a lot of work in the Behavioral Health Services Department that acknowledges that what we need in behavioral health care generally is ongoing care. What we need less are episodic moments of crisis and handoff, right? What we need that, but then we need that handoff to result in lasting, ongoing care. And the fact that the CARE Act program will be tracking progress in care over a year with an opportunity to extend that beyond a year is very helpful in its focus on longitudinal care. I want to note that this is, of course, a pilot. San Diego County is the largest of the 7 counties across the state of California that's participating in this first wave pilot. And that means that we have a lot to learn as this gets rolled out. This is a new program. It's a new effort. We do have hope that it can be helpful for the relatively narrow band of people who are meant to be helped by it. But we're also going to be taking every advantage of opportunities over the course of this pilot duration to learn as much about it as we can. The state is very invested in evaluating this program, and we also will be investing local energy and thoughtfulness in determining the effectiveness of this program. And we'll be thinking about that evaluation in a case-by-case process, case-by-case way, but also we'll be thinking about its impacts across certain kinds of communities of identity, geography, demographics, et cetera. And we will approach that evaluation with a commitment to equity that really reflects all of the work that happens through behavioral health services and across health and human services generally under the leadership of Chairwoman Nora Vargas. Thank you. Oh, and I'm so sorry. I want to now introduce Judge Kimberly Legata of the Superior Court, and I have a few little introductory remarks. She's been a Superior Court judge since 2010, and is the supervising judge assigned to the implementation of CARE Act proceedings in the San Diego County Superior Court.
All right, thank you very much, Chairwoman Vargas, for this kind invitation and an opportunity to speak. I am Judge Legata, and I, at this point, am presiding over our CARE Act proceedings in the San Diego Superior Court. Just a little bit of background information. San Diego was chosen as a Cohort 1 county, one of 7 California counties, entrusted with executing the mandates of the CARE Act statute, which was enacted in 2022. For the past year, our court team has been working internally and collaboratively with the county team to implement the CARE Act within the spirit of the statute's legislative intent. Our court has committed valuable time and resources to initiating CARE Act proceedings, and we are well prepared to begin petition review on Monday, October 2nd. Our CARE Court proceedings are guided by the legislative purpose and intent of the CARE Act. So I'd like to talk a little bit about that because I think the legislative intent behind the CARE Act is an important guiding principle in how we implement CARE Act proceedings. The legislative intent of the CARE Act is to provide services and support to those persons in our community who suffer from untreated schizophrenia and psychotic disorders, which can lead to risk to their health, safety, and possibly homelessness. The CARE Act is intended to intervene prior to possible arrest and involvement in the criminal justice system. The CARE Act provides a framework to ensure that our judicial role is followed, and that role is to provide oversight for comprehensive treatment, housing, and supportive services for persons with these complex behavioral health conditions so that they can stabilize and find a path to wellness and recovery. At the same time, CARE Act observes individual rights. Self-determination and civil liberties are important values in our community, which can be advanced and protected for individuals with untreated severe mental illnesses through the appointment of counsel, the Public Defender's Office, legal counsel who will be present throughout care proceedings, care agreement, care plan, and graduation, as well as a focus on and promotion of supported decision-making. Our court focus has been in 3 key priority areas: access, collaboration, and support. I'd like to talk first about access. This Monday, October 2nd, as I mentioned, our Central Courthouse, Vista Courthouse, El Cajon Courthouse, and South Bay Courthouse will accept CARE Act petition filings. All CARE Act hearings will be held at our Central Courthouse, Department 1203, as part of our collaborative courts. That courtroom will be closed, however, because these proceedings are confidential, as you can imagine. We allow remote appearances, so at the convenience of the parties, they can remotely appear in the courtroom, and we will have video equipment available for that CARE courtroom remote access. I do want to talk a little bit about, in very general and basic terms, who can file a petition and what are the eligibility criteria. behavioral health services, as well as 11 additional designated adult persons, from family members to treatment providers to law enforcement officer, are authorized to petition on behalf of an adult that they believe is suffering from a severe mental illness and who is unlikely to survive safely in the community without supervision, and the person's condition is substantially deteriorating, or who is in need of services and supports in order to prevent a relapse or deterioration that would likely result in grave disability or serious harm to the person or others. Severe mental illness, as Dr. Bergman has indicated, is narrowly defined as schizophrenia and other psychotic spectrum disorders. The person who files the petition is named the petitioner. The person who is the subject of the petition is named the respondent. Behavioral Health Services has indicated that they anticipate approximately 1,000 petitions will be filed in the first year, and that close to a third of those petitions will meet CARE Act requirements. Our court is ready to accept petitions on October 2nd countywide. When a petition is filed, and I'm going to give you just a very basic overview because the statute is complex procedurally, a judge reviews the petition, decides whether the respondent is eligible for CARE Act consideration, and if yes, sets an initial hearing with the parties. Behavioral Health Services will file a report, as Dr. Bergman said, with the court opining whether the respondent is eligible. BHS is substituted at that point as petitioner, and the public defender is appointed to represent the respondent. If the respondent is deemed eligible for CARE Act services, the parties meet in court to decide on a case agreement or a case plan to support the respondent's recovery and stability. At the case plan hearing, the court adopts the approved case plan, and the care team, as Dr. Bergman mentioned, is responsible at that point for encouraging and engaging the respondent's voluntary participation. The court will set review hearings to monitor progress and address the need for modifications, if any. Care plan services are in effect for 12 months from the date that the plan was approved. At the 12-month date, a graduation hearing is held. The care plan can be extended for an additional year if the parties so request. The second focus of our court has been on collaboration, which is important under the statute. Collaboration with the parties to the CARE Act proceedings and community service providers to formulate a case plan with appropriate wraparound therapeutic services and support to address the respondent's individual needs. The best fit within our court to hear CARE Act proceedings is within our collaborative court team, consisting of judges who are both knowledgeable as to mental health issues and caring. Proceedings will be held twice weekly on every Wednesday and Thursday. Our collaborative court judges have special training and expertise to preside over mental health cases, and they can assess alternative options with each other. They can conduct court proceedings in an informal and non-adversarial atmosphere, which is also within the spirit of the CARE Act. And finally, our third focus and priority is to provide legal support and supportive decision-making for both petitioners and respondents. Our court chose to apply our state fund award primarily to pay for legal support services for both petitioners and respondents. We have expanded our Central Court Self-Help Center, which is staffed with CARE Act trained personnel who can assist the parties as needed through each step of the court process, beginning with filing the petition and thereafter. This is also consistent with our commitment to supportive decision-making for the respondents. We intend to expand our self-help centers